I'm Sarah Peart, Director and Solicitor in the Childcare team at Duncan Lewis in the Leeds office. And I've got Sophie Jensen with me, who is also a solicitor in childcare at Leeds. We're going to talk today about the circumstances in which social care can legally remove your children from your care. There are very limited circumstances in which social care can remove your children from your care. And on the whole, they need a court order. They cannot remove your children from your care without a court order, and so you will get notice of a court hearing on the whole, which you will attend, and you have the right to be represented. Representation is free, and so it's really important that if you're told that social care are considering removing your children from your care, that you seek urgent legal advice straight away. Social care can, in certain emergency circumstances, apply to the court without telling you. Examples of that would be if they think that you would be a risk to your children if you knew about the court proceedings, or if you might remove your children from the area or from the jurisdiction if you knew about it. But those circumstances are very rare. The police also have powers under which they can remove children for a very short period, for 72 hours, and that doesn't require them to go to court. But again, that's in extreme circumstances where the risks are very immediate, and the police take the view that they need to remove the children for their immediate safety. Other than that, an application to the court is required.
There are different orders that the local authority can apply for in order to remove your children from your care. The first one is an emergency protection order, and that is an order which would allow the children to be removed for up to 8 days if they believe that the children are in immediate danger by being in your care. Generally, the local authority will apply for an interim care order. Now, that is a public law order which would give the local authority parental responsibility. As Sarah said, you'd most likely be given notice of when this application's made and be asked to attend court to confirm if you agree or disagree to this order being made. Finally, at the end of care proceedings, the judge will make a decision about where the children should live, and if a final care order should be granted. The judge will decide if they think that the threshold for care proceedings has been crossed, and if in the end the children should stay with the parents, or sometimes they might go with a family member or go into foster care, or in some cases even be adopted. This is why it's very important right from the beginning that you seek legal advice so that you can be represented and your views can be put forward within care proceedings.
There are circumstances in which a family can consent to their child going into care, and that's called Section 20. And often social workers will speak to parents about whether or not they will agree to the children going into care, and they often describe that as a temporary measure. We would strongly advise you to seek independent legal advice before you enter into any such agreement. It's important that you know your rights, because as we've outlined, social care cannot remove children from parents without court orders or by the police doing so. And so it's really important that you understand that before you sign any agreement to a child being placed outside of your care, that you know your rights and that you make sure you're not entering into an agreement which could be difficult to come out of.